Well, it's 8 o'clock here in Los Angeles. Good morning, everyone. Good afternoon, good evening, as the case may be. It's a pleasure to see you all again. Today is June 3rd, 2021. Excuse me. And this is Will Work for Food, the New Possibilities Hour. This was started by Natalie Armstrong Moten back in the spring of last year when the pandemic set in, as most everybody knows, and then joined by Jeff Kachavin, and then myself at the beginning of the year. So these presentations take place weekly, and nobody is asking for any money for these. It's just asked that you donate to a charity or a food bank of your choice or of the speaker's choice to help fight food insecurity around the world. And in that regard, Jeff, what's the total today that we know of that has been raised?
Jean, I am just delighted to report that so far our extremely generous audiences in the litigation and alternative dispute resolution communities have contributed $114,253, of which we know, to food banks worldwide. So thank you so much to our generous audiences. And if people are moved to contribute, and if they're comfortable letting Natalie know what they have contributed, we're delighted to add it to our running total to help fight food insecurity. Thanks to our speakers. Thanks to our audience. Jean, back to you.
Thanks, Jeff. That is just so fantastic. It's amazing what one person joined by other people can do, and kudos to everyone. And what a great difference all of us, everyone that has ever been on one of these calls, everyone who's ever spoken, is making in the world. So thank you for that. Our speaker today is Mills Gallivan. Mills is a personal friend. It's been an honor and a pleasure for my husband and I to know Mills and his wife for as many years as we have, and I'm sure that you will thoroughly enjoy today's presentation. And by way of background, Mills is a graduate of Vanderbilt University and the University of South Carolina School of Law, a different USC than we have out here in Los Angeles.
It's a real USC.
Right. And he is a senior partner at Gallivan White Boyd in South Carolina, a litigation boutique serving clients in the Southeast. He has over 45 years of experience as an advocate in cases involving personal injury, administrative law, business, and commercial litigation. His current practice focuses on strategic resolution of complex business and legal issues. And I found his biography on his website to be so interesting and different than most bios are, that there are a couple of passages that I would like to read as part of the introduction. And he starts with, "It is not unusual for someone to ask me, why did you become a lawyer and would you do it again? The answer is easy. I became a lawyer to help solve serious legal problems that people and businesses have been unable to resolve on their own. I tell people that I am in the problem-solving business. The most satisfying days for me are when I can offer a previously unthought of solution, which is the essence of being a counselor at law. I view the law as a calling and a true profession. I have been extraordinarily blessed in my career and feel a profound duty to give back to the legal profession. I have dedicated significant time and talent to improving the profession and mentoring young lawyers. My passion for the law and helping younger lawyers has led me to a number of leadership roles in legal organizations that advance the rule of law and work to preserve the civil justice system." And so at this point, let me just insert here as an example, some of the many organizations of which Mills has been a president. He just became president this last month in Lawyers for Civil Justice for the 2021-22 calendar year, and that's a national organization. He was president of the Federation of Defense and Corporate Counsel. He was chair of the dispute resolution section of the South Carolina Bar president of the National Foundation for Judicial Excellence, and that provides judges around the country, the U.S., with education on legal issues, and was sponsored by DRI. He was president of the South Carolina Defense Trial Attorneys Association, and maybe not most importantly, but for a lot of fun purposes, a past president of the Mardi Gras Charity Ball of Greenville, South Carolina. And then in conclusion, I think that this is worth hearing. Would I be a lawyer again? That's the question. Absolutely. It has been a wonderful privilege and an honor to practice law. I would recommend a legal career to anyone who is intellectually curious and who seeks to serve in a unique profession which resolves societal problems through the rule of law. And my friends, that's essentially what we do day in and day out as lawyers, as non-lawyer peacemakers, whether we're a lawyer or not, but mediators, arbitrators, etc. And so with that, I turn it over to you, Mills. And if you would tell us a little bit about your food bank, please, the Harvest Hope.
Yeah, thank you, Jean. That's an introduction my mother would have been very proud of, and my father would have said, "Who the heck are they talking about?" So, it's a pleasure to be here today. I think this is just an outstanding concept of gathering people together, education, and combining that with helping others. So Harvest Hope is a food bank that's here in South Carolina. It's been here for a number of years, and it is a tremendously effective organization. Last year, they fed over 789,000 families 25 million meals. And that's really kind of hard to get your head around, particularly in the COVID year. South Carolina only has 5 million people. So clearly we've got a population that is in need of food. And so it's a great organization. I'm sure they would appreciate any help that any of y'all wish to send their way. So that's enough about that. Let me get started this morning. The talk I'm going to give, there are two things about it that I would say. I have pre-recorded it, and I do that when I do these virtual talks, and I just got in the habit of doing that, but that gives me a little bit more control. Not that lawyers are control freaks, but so I have my IT guy here just in case something goes wrong. I tried to get Jean to load it up and play it, but she declined. So if there's a problem, it's on my end. But this talk evolved out of another passion I've got, and that's a passion for photography. And I gave a talk a number of years ago on sort of the correlation between some of the things that you do to take a good photograph and some of the things that great photographers like Westbrook or Ansel Adams did, and how that plays into problem solving and mediation and looking at it. So over the years, I've given that talk, and it's kind of morphed into this, which is what I consider to be, ways that we can be innovative. And obviously, 2020 was a year that we all had to change, and we had to change in a big way, and we had to change real fast. And I think that in some respects was a great thing. I know I work with the South Carolina Bar on dispute resolution, and they were wrestling with the issue of whether or not you could really do mediations in a virtual environment. That question got answered real quickly last March. It went from, well, can we do this, to how do we do it, to, everybody was doing it. So I think we have seen some really positive changes in mediation, particularly with the virtual abilities that we've got now. And I think a lot of those will stick around. There's some things that I like that really actually work better than having people there. One of them is you can usually get the insurance adjuster or the decision maker or the risk manager into the process, whereas before it was easy for them to say, I can't travel, my budget's not there. They don't have an excuse now. You sit at your desk, I don't care, but this is your case and you're a part of it, and we're going to be here for the day, so you can join us. And sometimes they're happy and sometimes they're not, but that's that. So Having said that, what I'd like to do is see if I can get this video up and share my screen and play it. And then it's about 30 minutes, give or take a little bit. And then at the end of that, I'll be happy to answer any questions that you might have. And so we'll see how this goes. So I am going to push share screen. And all right, Tommy, help me find. Good afternoon. It's a pleasure to be with you today to talk with you about something that's very near and dear to my
That was working.
heart, and that is mediation and how to improve the process. So today what I want to do is talk a little bit about some different approaches to mediation, as well as our roles as mentors, teachers, advocates for a better process. I'm going to share some ideas and concepts which I've seen used very effectively in mediation. I'm also going to talk about a few things that I've done. And so what I'd like to do is start, and hopefully technologically I can handle this. I'm going to share my screen so that you can see that. And hold on, there we go. So we're going to talk about what I would like to think of as alternative disruptive resolution. A little bit different term, but I think that's the period that we're in now. We're in a disruptive period. And so let's talk about approaches. And to me, that's something it's defined as a road, a sea passage, a path, or an other way leading to a place. And as mediators, I think we really have the opportunity to light that path and to show the way for the advocates. I think I hadn't ever met a mediator that really wasn't interested in improving the process and oftentimes teaching or helping the advocates along. The advocates obviously have to very carefully choose their approach to each mediation. But ask yourselves, honestly, do most lawyers have a clearly defined approach? Maybe not. So COVID-19 has changed everything about the way we do things. This is the Choluteca Bridge and the Choluteca River in Honduras, and it was destroyed over and over and over again by hurricanes. And so the Honduran government came up with a great idea. They were going to build a hurricane-proof bridge. Well, this is the Choluteca Bridge in Honduras, and it was built to withstand any hurricane that ever came along. And as you can see, the bridge clearly withstood Hurricane Mitch, but the hurricane changed the course of the river. And so now they have a bridge to nowhere. And to me, that's kind of representative of how do we deal with the change that COVID-19 has forced on the litigation world. But it isn't just COVID-19. I think lawyers in general are having some lawyers are having a hard time adjusting to advocating in the context of mediation. And without trials, that's really their best shot at getting the case resolved. So I think as mediators, we need to think of ourselves as the gatekeepers for innovation and creative disruption in ADR. So I wonder often, is mediation really the alternative? And these are some statistics from 2017. I tried to get updated ones, but there hadn't been a lot of trials since then. But I think it's representative of what we will return to, and that's in Greenville County. Over 8,000 complaints, but only 20 jury trials. I think the ADR numbers are probably off because some people don't report them. 3,000 eligible for ADR and 236 fully settled. That number I know is inaccurate, but the savings estimate probably also low. So the trial by jury has just been disrupted, and the professional life and livelihood of trial lawyers has been disrupted. And just like the changes in healthcare, I think litigants expect us to move from volume to value. But what is value? And I would suggest that it's early resolution, less costs, better results. The skill set of a great advocate in mediation is different from trial skills. And Malcolm Gladwell posited in his book Outliers that it takes 10,000 hours to completely master a skill. Superior dispute resolution skills and tactics, to me, offer a distinct advantage, but they have to be practiced, and they have to be refined, and they have to be enhanced to really be of value to the litigants. This is what I think of as the impact of a bad approach. The approach to a mediation is much like a pilot approaching an aircraft carrier landing. It's complex, it's multidimensional, it requires skill, practice, execution. The similarities are striking, and in a mediation, the landing strip is a moving target. Same thing, the plane's got to stay in the air till the very last minute. The glide path's got to be correct. Pilot must constantly correct for wind and a rolling deck. As the air boss, I believe the mediator is the one who's got to constantly monitor all of these different things that are going on. There's an old military saying I like it: strategy is for amateurs and implementation is for professionals. And we are the professionals. We're the ones that manage the implementation or the landing, or in this case, or in the case of a mediation, the settlement. So these are what we all know are traditional approaches to mediation. They relate to the form and the function of the mediation. But to me, innovative and creative approaches deal more with the style and strategy of the mediation. So I love this quote by Ansel Adams: "There's nothing worse than a sharp image of a fuzzy concept." And lawyers create the message, but the mediators are often the ones who are delivering it. Good lawyers will take their message, they'll tweak it, they'll pressure test it, they'll review it with their client, they'll get them on board with that message. But whether the message is written or oral or in pictures or video, the medium is the message. And that's a phrase coined by Marshall McLuhan, meaning that the form of the medium embeds itself in the message, and it creates a symbiotic relationship by which the medium influences how the message is perceived. And we can help the advocate deliver the most powerful and convincing message if they allow us to do that. I've got a friend who is wonderful at sending a message, and he works on his PowerPoints. And literally, in a big case, he may revise his PowerPoint 100 times. Our job as mediators is to deliver that message in a way that appeals to the other side, to help them see what the plaintiff in that case, or in any case, is seeing, or the defendant is seeing. And oftentimes, I really believe the mediator is the medium, but we're also the message. So just remember that that message is being embedded in you. These are some of the things that we've all had to deal with recently: virtual mediations, telephonic mediations, in-person and virtual combined, doing mediations in steps or segments. Fast-track jury trials are also becoming very popular, and more arbitration. But what's next? What's around the corner? What is artificial intelligence going to do to our profession as mediators? Every case needs its own approach, and I think we shouldn't be afraid to ask the parties hard questions. Let them mix it up a little bit. Mike Tyson said everybody has a plan until they get punched in the face. But as the mediator, I think we've got to be adaptable. We're monitoring that process. We help the parties find the right message and the right medium. So what are some reasons to change? And I'm talking not just to the mediators now, but also to the lawyers. I think predictability, it can be good, it can be bad, but you've got to be consistent. And once you choose a style, or once you choose a path, it's important to stick with it throughout the course of a mediation. It doesn't have to be the same in every mediation. Good mediators, I think, keep a book on each lawyer. I know what some lawyers like, what some lawyers dislike, and I know their tendencies, and I can sometimes predict where they're going and how they're going to get there. So how much they share with me is certainly their prerogative, but how much I share back with them about what I see that might help them is kind of in my prerogative. But so depending on the lawyer's goals, predictability may be a good thing, may be a bad thing. I don't think lawyers should be afraid to be unpredictable. but they've just got to stay in character. And the same for the mediator. You don't have to do the same thing in every mediation. In fact, it may not be good to do the same thing in every mediation. But again, stay in character and be consistent with your message throughout the course of the mediation. So that really goes to, does the book match the cover? And I tell people, sincerity is the hardest thing to fake. It's important that the book matches the cover. You know, a couple of years ago, my wife was going to a book club, and she was supposed to be reading a book, I think, about growing up in Appalachia, and she was reading it. She started reading part of it to me, and it was a gay porno book. And I said, I don't think that's it. She'd gotten it from Amazon. The cover on the book was correct. The interior, the contents were not the book that she was supposed to be reading. And she went to the book club and she showed it to the author, who of course was aghast and was immediately contacting Amazon to find out why the contents of her book weren't in her cover. And so that's important. The book's got to match the cover. Mea culpa has worked if the lawyer is really good at it and sincere, or the client's really good at it and sincere. But if they're not, again, sincerity is the hardest thing to fake. I've always heard, growing up in the South, if you don't open your mouth, they won't know. And there's a lot to that. I talk about a WATNA, which is the worst alternative to a negotiated agreement, and that's just when everything blows up. I think first we must do no harm as the mediator. We've got an obligation to keep the process going, and we don't want to see things blow up. It's a safe harbor. Mediation should be a place where people shouldn't be afraid to ask questions. We shouldn't be afraid to ask questions that challenge the parties. And I think sometimes it's our job to disillusion the lawyers. The parties, disillusion the parties. Sometimes you have to disillusion yourself. And I do that, I think, by asking rhetorical or non-threatening questions, questions that'll lead to informative answers. I recall a number of years ago, I was in Dublin, and I was had hired a guide to take me around Dublin. He was a college history professor, delightful guy. And we stopped by a bar at the Shelburne Hotel, a fairly famous bar called the Horseshoe Bar. And he said, this is where all the famous people come to have a drink. And he said, every once in a while, my wife and I, we come down here and we disillusion ourselves. We believe we're just as good as they are, and we have a drink. And it always stuck with me. And he was practicing the art of disillusionment. And oftentimes, I think that's our job. We've got to practice the art of disillusionment, sometimes for ourselves, but oftentimes really for the parties, so that we are getting them to the place where they can settle, where they know what they really need to know to get a case settled. This is a good example of a picture being worth 1,000 words. You got to stay, to me, totally focused on everybody in the mediation. And I think that is something that is incredibly difficult to do. Bill Clinton is a master at focusing on the one individual with whom he's talking at the time. And it is incredibly disarming. I have not met him, but I have talked with people who have. And they say that it's just unbelievable. He does not take his eyes off of your eyes. And you begin to understand and believe that whatever he's telling you is true, and that he's listening to and taking every word that you are saying in. And so as a mediator, you should never be texting or email or talking on the phone, except if you're doing that with the parties. If you are, I think the message is that you don't care, or this isn't my first rodeo and I don't need to listen to what you're saying. And both of those are, to me, very bad messages. So the parties, I think, particularly in personal injury cases, and the plaintiff in particular, they really see this as their day in court. And so to me, 90% of effective mediation is listening, and it's that last 10% of listening that separates the winners from the losers. And there's a fly fishing guide, a saltwater fly fishing guide I love, a guy named Flip Pallett. And Flip is a professional guide, and he talks about being hired by people to go out and fish. And he said they'll come down here and they're not ready. They can cast okay, but they really can't cast into the wind, or they can't cast that last 30 feet. And that's the 30 feet that's critical. He said, I can put them on the fish, but if they can't cast and get the fly to the fish, and it's that last 30 feet, we just wasted a whole day. And it really hacks him off. So before I go fish, I practice a lot. I don't want the guy to be mad at me, but that's what listening is. It's closing that last 30 feet, that gap. Legend has it that St. John Birchman's, who was a Jesuit priest, was playing pool one day at seminary, and somebody asked him and said, what would you do if the world was going to end in a minute? And he stopped and he thought about it. What would I do? I'd hit this shot as well as I could. So he was just totally focused. He was into what he was doing right there. And I think right there and then. And I think that's what we are charged with as mediators, to be completely focused on what's going on right there and then. So when you're mediating, you need to be in the moment. You need to be totally on your game and all in for the parties. And if I do a full day mediation of anywhere really from 6 to 10 hours, sometimes longer, but usually kind of in that range, it's intellectually challenging, and it's exhausting and can be exhausting, and that's okay. That's what it shows, that you were in the game and you were paying full attention to what was going on. I love this idea about Sherlock Holmes, and that is that you're theorizing before you have all the data. The facts are the facts, and a party can spin them. We can spin them all we want, but ultimately, everybody's got to face the facts, and we can't let the parties be seduced by their own version of the facts. Again, that goes back to practicing the art of disillusionment. So we should use the facts to our advantage, but we also need to be wary of the facts being presented to us. So I always say trust, but verify. And, you know, again, we can fall into routines that can be problematic. This is a picture of the Challenger astronauts. That's a picture of the Challenger exploding, which many of us remember, may remember where we were, and what a tragedy. And it really came from a concept called normalization of deviance. And it's getting lulled into that false sense of confidence because something has worked. NASA repeatedly ignored Morton Thiokol's warnings on those booster rockets. And the reason they did is because the seals were working. They hadn't been a problem. They're getting these emails saying, we think that the seals could be a problem in certain temperature ranges. Well, it's Florida, hadn't been a problem. They had an aggressive launch schedule, so they ignored them. They continued the status quo, and the result was a disaster that cost these 7 astronauts their lives. So everything we do in a mediation should be strategic, and it should be well thought out. And if it works once, it may or may not work again. So it's important as mediators that we don't confuse luck with a sound flight plan. Again, another Jesuit philosophy, quality, not quantity. And I'm constantly astounded by the number of good lawyers I see who come into the mediation without a plan. They have a target, but they don't have a plan to get there. And it's kind of like the old maps. We used to have maps in our glove boxes. Now we've got GPSs built into our dashboards. The maps required planning. You had to sit down, you had to figure out where you were going, you had to, you know, figure what road you wanted to take, where you might get gas or stop for food or a restroom. Now you just plug in where you want to go and you go, voila, you're there. And that works great until there's a satellite failure or there's some other kind of electronical failure. But I think mediators can help put people back on that planning path by identifying key issues in the case and having an overall strategy or plan for resolution and tactics that match that strategy. How are you going to conduct the mediation so that the parties get the best result? And I always think, you know, use the KISS principle, keep it as simple as possible, just a minimalist approach, focus solely on the issues that will prevent or will enable a resolution. And we can't get distracted by that background clutter of non-issues or a personality or an individual who's riding off the range. It's our job to control all that. So I think storytelling is probably the most effective way for me in a mediation to convey points. I think it's also the best method that the lawyers can use to tell their compelling story of why their client's position is valid or should be accepted. And it takes time to develop a story. You've got to have a theme, you got to have a hero, you got to have a moral. You know, there's so many things that go into telling that story. But in today's world, and by that I mean 2021, and even for the last probably 5 or 6 years, it's the iPhone and the iPad that are the storytellers. And think about, everything is getting caught on video, and some of it's good and some of it's not. But you got to know, even then, what is it you're seeing? And several years ago in North Charleston, a police officer shot a man, and there was a video of it. Somebody videoed him shooting this man, and it appears that he is shooting this individual in the back. And so there are outcries. The officer's been charged with murder. The iPhone video was given to the FBI, and the FBI broke it down frame by frame. And I've seen that frame by frame video. And what happens in it is to me, startling. The police officer and the victim are struggling, they're fighting, and you see the victim grab the police officer's taser and pull it out of the holster. And as soon as it starts to come out of the holster, the police officer is drawing his weapon with his other hand and bringing it up to fire. The victim is kind of turning away and pointing the taser, and the police officer starts to fire as the individual turns and ultimately shoots him in the back. And then you see the taser fall to the ground. All of that is very clear in a frame-by-frame analysis, but if you watch the video at full speed, you will never see it. And it's only that full-speed video that's being shown on the TV or on the internet or wherever things like that are shown. And people believe what they see, not what they hear. And even when you got the right facts and you got the right video, going back and convincing people that now what they're seeing is different is a hard sell. And it kind of goes to when I was a young lawyer, introducing a photograph into evidence, you had to authenticate it. Nobody thinks about that anymore, but make sure the things that are coming in that are being presented are in fact authentic. And it's the lawyer's job certainly to advocate, but they shouldn't misrepresent the facts, and they've got to present in a manner most flattering to their case, and I understand that. But again, tell a story, let the lawyers tell their stories. Style to me is a big deal, and I love photography, and these are, you know, just two different versions of the same picture. But styles really are about choosing the approach for the lawyer, but as well as for the mediator. And you got black and white, or color, or landscape, or portrait, or architectural, impressionistic. I mean, you can go on and on and on with style. I think one thing I challenge you: have you ever used a PowerPoint yourself to open a mediation? I've done it on several occasions with cases that were either volatile, for lack of a better word, or extremely complex. And it's just a great opportunity for the mediator to set the tone, to lay out how the mediation is going to go, to establish a theme, to identify the issues, agreements that have already been reached. And again, for whatever reason, I can say it, but if I've got it up on a screen, people buy into it. They tend to believe it. So I think the style depends on the subject matter. Lawyers have got to be strategic. You've got to pick a style that works with the case, the client, the adversary, the other party, the mediator, and they got to be intentional in that. Picking that style and having tactics that really complement the style. So I want to just go through a little exercise I do, and I've done it before, particularly when I've got a live audience, and it's a lot of fun. And this is a little bit because it's virtual and we don't have an opportunity to have a lot of discourse back and forth. It won't have quite the same effect. But I'm going to show you some pictures, and I ask the audience typically when I do this, tell me what the story is. So I'm going to just go through these slides. I'm not going to say anything. Just look at them and think about what the story is that is being told. So now I would generally ask people, tell me what happened. What's the story here? And it's always fascinating to me to get people's responses. And some people will say, well, clearly, you died, or the father died, or the child died, or the picture at the end, the child was hurt, but the child's okay now, or at the end, the child's pointing out to sea, which is, where the other person was. I get all kinds of answers. It's always fascinating to me to see this. The truth of the matter is that those photographs are completely unrelated. A couple of them are stock photos. A couple of them are pictures that I took. They have nothing to do with each other. They were taken at entirely different times, some by different people, some by people I don't even know. But I can put them together to tell a story, and it's that montage theory of movie making, that 1 + 1 = 3. And Daniel Kahneman, who is a brilliant social psychologist, economic psychologist, I always forget his title exactly. The perception of intention and emotion is irresistible. And I think in the mediation, as we're trying to get to the truth, it's important to be able to persuade the other party to look at the truth, and that is more important than their theory of the facts. And Kahneman wrote, coming back to me now, Thinking Fast and Thinking Slow, and he's a Nobel Prize winner. I should be able to remember that. But I believe focusing on the stories is the way to tell the most compelling story that you can, and using anecdotes. And I often tell plaintiffs' lawyers, pigs get fat, hogs get slaughtered. I mean, anything that you can do, I think, to use anecdotes is helpful in a mediation. One of the books I read years and years ago, and I've still got it and go back to, it's The Hidden Persuaders by Vance Packard. And it explores the use of consumer motivational research by advertisers, subliminal tactics, how to manipulate expectations, how to induce a desire for products. The lawyers that can do this through storytelling and messaging are going to be the most successful lawyers. So using pictures in mediation presentations, to me, is not only powerful, it's effective, and it's really probably not used as much as it should be. So the great storytellers, to me, can link ideas into scenes. Those scenes lead the listener to a specific conclusion beyond the individual scene. And that's just like the bike pictures. Again, you're putting together in your own mind what the answer is, what the result was. So adversaries always worry about anchoring. Cracks me up. I'll go into the plaintiff's room and I'll say, I need a demand. And they'll say, we're not giving a demand until they make an offer. And I'm thinking, have you lost your mind? You've got an opportunity right now to anchor this mediation. So I'll go back in, talk to the defendants and say, they passed on the anchor. Why don't you throw it out? So if it's they think it's a $500,000 case and you think it's a $150,000 case, why don't you make them a decent offer? But send them a message that you're willing to play, but it's going to be in a realm that's realistic, and make a $25,000, $50,000 offer with a statement that, look, we think this is what the case is worth. And I think they then basically have kind of put the negotiations on their end of the field, which is great. But I think the anchor is also set very early with the choice of the mediator, the format, the time, the place of the mediation, when the lawyers and when the lawyers recommend target settlement numbers to their clients. That drives me nuts. I tell lawyers, just give them a range. don't lock yourself down to this is a $700,000 case. So this is a case that we really ought to be seriously thinking about settling between $500,000 and $800,000. You know, something. Give yourself a range, because the clients remember those numbers. And I tell them, you know, it's you got to look at the front and the back, the start and the finish. It's like snipers. They're taught front sight focus and rear sight focus. You got to have that rear sight focus, that close in focus, in order to hit the target. But you got to line that up with the front sight. So you need both to hit the target, and that to me is very important. A couple of takeaways. We are clearly in a period of transformational change. The jury trial, to me, is also going through that same transformational change, and I think that's a huge opportunity for ADR professionals. You don't have to be an innovator. You don't have to be an innovator, but parties are looking for fast followers, people who can deliver value through early resolution of problems. I've got a friend, great lawyer. He dabbles in mediation, and when the virtual mediation started, somebody wanted to do one by Zoom, and he couldn't finish it. He had to call a friend. He didn't call me, but he had to call a friend who actually had to come over and help him finish the Zoom part of it. So be a fast follower, but know what you're doing. So hopefully these are some ideas that get your creative juices flowing. Define your own style and your own creative process. The pace of change is only going to accelerate. And to me, that is a really exciting thing. It's a wonderful time to be in the ADR profession and to help parties get matters resolved. So I hope that I've given you some things to think about today. Thank you for your attention. It's certainly been a pleasure to be with you, and I'm available to answer questions. And I just hope I've finished talking before you quit listening. So have a great day.
Thank you so much, Mills. That was fascinating. I especially like that Challenger example. I remember that and use that a lot. There's no such thing as an accident. It's a planned accident, so to speak, even if you didn't consciously plan it. So we're looking forward to some questions. Jeff, I'll hand it off to you then.
Thanks. Well, we have a lot of people here, Mills. Thank you so much for an excellent presentation, to which everyone listened so attentively, and I'm confident people have questions. For those of you who do have questions, you're welcome either to type them into the chat and we'll read them out loud, or if you would like to raise your hand or just unmute yourself. We usually have a pretty well-behaved civil crowd. So if people just want to unmute themselves and ask a question or out loud, that's great too. Please. Well, Mills, while we're waiting for other people to ask questions, let me ask you, can you call to mind a mediation where a lawyer really just did a great job, where you thought, oh, this lawyer is really, I wish we could bottle this person and sell them at the store or her at the store? And tell us what makes a really great performance by a lawyer to mediation? Mills, we can't hear you again. No, still no sound.
Is your mute button on?
Usually we just get questions in the chat. Maybe we need the answer in the chat this time.
Well, we definitely have a lot of discussion going on in the chat.
Okay, Mills, try to unmute yourself there.
Yeah.
No sound.
playing with those videos, I guess it just doesn't, it messes everything
Eric
up.
Van Ginkel, Eric, you had a comment there in the chat. If you're comfortable, do you want to unmute yourself and comment?
Sure. Mills, thank you for your excellent presentation. The only thing that struck me as dangerous is offering a range of amounts, because, for example, if you're willing to pay, if you're on the paying side, if you give a range of 300 to 500,000, let's say, the 500,000 becomes the anchor. If you're willing to receive the same amount, that low amount becomes the anchor on your side. And I think that that's a dangerous experiment. What is your answer to that?
Mills, are you able to figure out the audio? And well, while we're still waiting for Mills, we have a lot of other talented people on the line. Does anybody have a thought with respect to Eric's comment about the wisdom of ranges? Sort of thing that Mills commented on and that Eric amplified. Any thoughts?
Well, this is Jean. I agree. People just hear numbers. And so if you're on the defense side, you will think the lower number, and that will be in the mind of the client or the claims representative. And if you're on the plaintiff side, it's probably the high number that people seem to cling to. It's definitely, I agree with the range as opposed to a specific number. But even with the range, there are problems. But definitely not a specific number. How in the world can you promise something that you have no ability to necessarily make happen?
I do want to say in reaction to that when a mediation gets closer to the end and you perceive an impasse, that in an impasse situation, it is oftentimes a good idea for the mediator to go to each side and see whether they can accept a bracket. It's called a bracket, but it could also be called a range. And within that range, if they accept that they're willing to talk within that range, there could be either an overlap or at least you can narrow the differences between the two parties. So that isn't, in my opinion, a very practical approach to break an impasse. But at the outset of a mediation, it seems difficult to me to come up with a range where that may very easily be misunderstood.
Okay, Mills, any luck with audio on your end before we have others comment? Okay, we've got the IT guru there. Jean, you were about to comment, please.
All right, how about now? Can you hear me now, Jean?
Oh, yes, Mills, great. Oh, we're so glad you're back. Please take the floor back.
Carol Ann's been looking for that button for years. If y'all share it with her, I'm in trouble. My comment really was directed more to what the lawyers are telling their clients before they come to the mediation, not what's happening in the mediation. So, I think they throw out a number for their client and those clients lock on to it. And all I'm saying is, rather than telling your client, this is a $700,000 case, give yourself some flexibility, because once there's $300,000 or $400,000 on the table, your client may want it, but they've still got that $700,000 in the back of their mind. So it was not, in the mediation. It's more of when I'm talking to the lawyers before the mediation and they start to kind of formulate, this is what it's worth. I'm going, well, just be careful, what you're telling your client. Give your client a range that would be an acceptable range to really start looking at getting the case settled.
So Mills, if you tell your client that this is a case, to use the numbers we've been batting around, a $300,000 to $500,000 case, and let's say you're talking to a plaintiff, a consumer type plaintiff in an injury or employment case, someone who's not seasoned in the business world or business negotiations, have you not, in essence, foreshadowed or signaled to your client that it's a $300,000 case and they ought to be okay with 300? Isn't that the message you're really sending?
You know, I guess I'd rather have them do that though, where they can tell the client we're going to work and we're going to negotiate and we're going to get as high as we can. But if they just set the bar at 500 grand and the most you can get is 375, then the client's kind of looking at the lawyer and saying, well, wait a minute, you told me it was a $500,000 case. So, you know, it's tricky. I mean, you know, the good news is I'm not having to advise those clients, but I know a lot of times when I'm in there, you know, the client will look at the lawyer and say, well, you know, you told me it was a $500,000 case. Why are you telling me now to take 350? You know, and I feel so sorry for the lawyer, you know, because they want to get the case settled, and it may be that something's come up in the mediation that changes their opinion, and they can kind of explain their way out of it. But I just think when they draw that line in the sand, sometimes it comes back to bite them.
Well, that is the challenge we face as mediators, where sometimes lawyers have engendered unrealistic expectations intentionally or more often inadvertently in their clients. What works for you, Mills, in trying to help get those unrealistic expectations back down to planet Earth?
You know, obviously, whenever I've got information about what jury verdicts were, even if it's somewhat stale, that's helpful. Knowing the jurisdiction helps. I mean, I know, you know, in Greenville, a case might be worth $100,000, but in Barnwell, which is one of our judicial hellholes, it might be $1 million case. So where you are in our state makes a lot of difference. You know, so that can help you explaining to a plaintiff that, look, this is Kansas, you know, this isn't Oz, Toto, and you gotta adjust for where you are. And this is what happens in our courthouse, which is around the corner. That's helpful. You know, a lot of times, you know, it's interesting. I mean, sometimes the lawyers want the mediator to be the bad guy. They want me to be the one to tell them, look, you know, you don't have a $5 million case. You know, it's just not going to happen. And if they want me to do that, I'm fine doing it. I don't mind doing it. But so it's, you know, but I think real-time information about what similar cases are worth is oftentimes very helpful. You know, with all the TV advertising, I mean, it's sad to me. I drive home and I see these billboards and these people jumping up and down, and, you know, my lawyer got me, you know, $500,000. And I'm thinking, the cases where I'm seeing $500,000 paid out on a personal injury case, the people are not jumping up and down. They're usually in a wheelchair, you know, or they are really, really injured badly. And so I think some of the public, when they go lawyer up, I mean, it's like a game show. I mean, you know, and so it's dealing with some of those expectations that, hey, look, your soft tissue injury, yeah, you got $2,000 in medicals, is not a $250,000 case. You just got to explain it to them. So.
Mills, we're just about out of time. I have two final questions for you. One, is there anything else? You were on mute some of the time. Is there anything else you're just dying to tell us? And number two, would you please put your email back in the chat? Yeah. Because I think some people will have follow-up questions for you.
Yeah, no, I'll be glad to. No, you know, I think that unfortunately during the period of time I was muted, it had to do with the sharing the screen. But you know, the question really was about that range and how you deal with that range. And the one thing I wanted to make sure is I wasn't talking about me giving a range. I was talking more about what the lawyers are doing with their clients to anchor them before we ever get to the mediation. And that's where it's sometimes difficult to, you know, talk that dog off the porch. So that would be it. Let's see.
Okay. And let's get your email up there. And thank you so much, Mills. You gave a lot of thought and preparation and preparing that video with all those vivid examples. That's one of the great hallmarks of a great storyteller, is to make it vivid and visual and exciting. And You engaged everybody and gave us a lot of valuable information to think about.
Well, it was
Thank
a
you so
pleasure,
much.
and I appreciate it, and I always enjoy when I'm available dropping in on these. This is a great series, and you know, you and Jean and Natalie have done a great job of promoting it. And thank you for having me. It was a true
You're
honor.
welcome. We're so glad you're part of it, Mills, and I hope people are moved to contribute to harvesthope.org, harvesthope.org, a most worthy organization. And with that, Jean, Natalie, back to you.
Great. Well, thank you again, Mills. It was a pleasure having you, and I will not forget that Bridge to Nowhere and the book with the wrong cover and the very interesting content, I guess. So thank you so much. Natalie? Yeah.
I want to just say thanks very much for proving your point by teaching us through storytelling. Well done.
Thank you. I appreciate it. I appreciate it very much. If y'all are ever down
Okay,
this
my
way,
friends.
hit me up and I'll buy you a drink.